Division 1 is now in session.
Please be seated. Good morning. We're here for oral argument in cause number 1 CACV 180632FC Hammett versus Hammett. These proceedings are being audio and video recorded, so we would ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, you are advised that you are responsible for watching the clock to reserve any portion of that time for rebuttal if you so desire. We've read the briefs. We've discussed this case in conference this morning. Counsel, you may proceed.
Thank you, Your Honor. Good morning, and may it please the court. I'm Charles Ross Cipher on behalf of the appellant, Ann Cuizon. The question in this case concerns a proceeding for annulment, a decree for annulment, in which the trial court allocated responsibility for a debt secured by the appellee's real property, required the appellant in its decree of annulment to assume responsibility for a debt which she did not take out, on which her name did not appear, and for which she otherwise would have had no responsibility. The problem is that the trial court didn't have statutory authority to allocate that debt to my client, and further, insofar as if this court determines that the trial court did have the statutory authority to make an equitable distribution of property and allocate the debt, it was an abuse of discretion. A proceeding for annulment is provided for under ARS 25302, which provides gives the trial court the authority to make allocations of property to the extent it has jurisdiction to do so. That statute does not make any reference to the allocation of debts. In 25318, which is the statute providing for the equitable distribution of property, proceedings for annulment are omitted. What this decree of annulment does in this case is picks and chooses where to treat the proceeding as one for annulment and where to treat it as one for dissolution or legal separation. When by the trial court in allocating the responsibility for the debt to the appellant, insofar as the trial court applied ARS 25318, was an abuse of discretion because this court has held in clarifying the Toth line of cases in 2010, the twin cases of Flower and Imbuden clearly state that it is not an equitable distribution of property, distribution that's substantially unequal for the sole purpose of reimbursing a purchasing spouse. That can be the only explanation for what happened in this case.
When a trial court is allocating property in an annulment situation, what do they look to? Is it do they just, here we had tenants in common?
Yes, Your Honor.
And what would the trial court look to in developing or dividing that property?
Well, in this case, there was the statute that was cited to the trial court is in Title 14, which provides that any real property held as community property with right of survivorship upon the entry of a decree of annulment is held as tenants in common, which is what the trial court did in this case and is not being appealed.
Does the statute specify what proportion ownership those tenants in common would have?
No, Your Honor.
Why do we assume it's 50-50?
Well, Your Honor, that's an excellent question. It wouldn't necessarily have to be 50-50 under my client's position. It's just that here there is no other justification for it.
Well, there's a justification for giving your client a substantially lower percentage than 50%, right? She didn't pay for it. The money that's used to pay for it has to be repaid by the other side. If there was never a marriage, as an annulment presumes, and there was never a community, what guidelines is a court to use in coming up with percentage ownerships? Otherwise, it seems that if we just assume that it's 50-50, that seems to put your client in a position of profiting from inequity.
Well, I don't think it's inequity, first of all, of course, Your Honor, but I would say that it would make sense that there would be a presumption of 50-50, that equal rights of the community property with the right of survivorship title implies equal ownership rights.
Certainly, joint tenants with right of survivorship implies that, may even require that. Community property would imply that, but there was never a community, or at least so we must now believe.
Correct, Your Honor. So
But I don't know of any doctrine under tenants in common that requires equal ownership.
I don't disagree with you, Your Honor. The decree in this case simply ordered that the parties were equal owners as tenants in common, and that's not being appealed. So in this case, they were found to be equal 50% owners of the...
Sure, that's not being appealed, it's not being challenged, but what is at issue, I think, is the trial court's understanding of what that 50% meant.
Isn't there a body of law that talks about partition of property for tenants in that situation?
Correct, Your Honor.
Why shouldn't we just apply that body of law?
Well, that's what the appellant asked for in the lower court, was for it to be divided as a partition action, Your Honor. So that's what we would...
And does equity factor into a partition action?
I'm not sure, Your Honor. I don't know the contours of the law of partition and the partition action. I suspect that the law of real property would come into play, which of course does not here. The problem here isn't that whether or not equity came into play in the division. It's that the court chose to divide the property equitably under 318, and that's a statute that authorizes the court to take certain considerations within the regime of community property. That regime of property division should not apply in this case to an annulment proceeding, because it's giving the benefit of community property to a partnership that doesn't warrant it.
Assuming we take 318 out of the equation here, because this is an annulment, does your client have equity on her side?
I'm sorry, Your Honor?
Assuming we take 25-318 out of the equation, does your client have equity on her side?
Yes.
Why?
Well, Your Honor, my client, there was evidence submitted that my client made significant contributions to the house purely in terms of financial. Such as they're on the record that she submitted invoices and a summary accounting of all her improvements, repairs, maintenance to the house, or to the condominium in this case. It was over $30,000 of receipts and invoices that was admitted into the record.
Okay.
Furthermore,
so that entitles her then to title free and clear of the money used to purchase it?
No, Your Honor. What entitles her to have her title free and clear is that she was gifted her 1/2 share of the house, of the condominium. So the question of whether or not the appellee made a gift to the appellant has been resolved, is our position. That the court found that it was a gift, found that the marriage was void ab initio, and therefore held that the parties were each 50% owners as tenants in common. That is the ruling, that part of the ruling is not being appealed. So when Your Honor speaks of the equity and the fairness, it is understandable that in retrospect it can seem unfair in the sense that the party now regrets making a gift. But it doesn't change the law of gifts. It doesn't change his intent at the time to make a gift. It doesn't change the contemporaneous conduct of recording the title so that all other parties could rely on that. That's the law. The equities of them. I'm sorry, Your Honor.
No, I'm sorry. I was just going to ask, isn't the only evidence of a gift here is the fact that he listed her on the deed?
No, Your Honor. In addition, the contemporaneous recording, which is considered, the actual transfer of possession under the Beckley line of cases.
But those are all Those are all based on a presumed marriage, which we know now doesn't exist.
That's true, Your Honor. Although they're more broadly based on the idea of that of a party being the natural object of one's affection. So at the trial level, it was not rebutted. I mean, it was not a contested issue whether or not a gift was being made. So there was no evidence adduced to rebut it.
Well, it's just odd that you were using a presumption of gift based on a marriage that doesn't exist.
Right, Your Honor. I would say that one again that the gift, it was found to be gifted. So at the trial level, whether I think an annulment proceeding would be an appropriate place for that to be contested, and for the whether the party, the donee, was the natural object of the donor's affection, whether there was fraud, inducement.
How much was intended to be gifted? Half? 10%? All?
Well, I would say, Your Honor, that at the time, with both parties considering themselves married, or at least intending to hold themselves out as married parties, it was intended to be a gift of everything in one half, in the sense that community party reflects an idea of marriage that we can't make perfect divisions, that everything is shared completely.
Well, when one gifts during a marriage, one gifts to the community, not to the other party. And here, there was no community. So what gift was intended?
Well, Your Honor, I'm not sure that I would agree that a gift is necessarily to the community. I think a gift can be to the other party solely. For example,
it can be, but I've never seen a case that says when you list both parties as title on real estate, that it's presumed that it's a gift of sole and separate property to the other party. All the cases talk about a gift to the community.
I agree, Your Honor. I'm sorry.
Here there was no community. What sort of guidelines do we have to determine what the intent, what the gift to the object of this gentleman's affection was?
Well, what kind of guidelines would there be, Your Honor, to determine whether or not it should be considered a gift under these line of cases?
No, what the quantity of the gift was, what the proportion of ownership was. Was the idea that the gift was sole and separate property to another person of title free and clear? Is it that there was a presumption that it should be 50-50 even though there was no community? Or is it a presumption that the percentage of ownership should be adjusted to account for the economic burden of making the gift? It seems that we have no idea.
Yeah, I'm not sure, Your Honor. I don't know if, for example, if it were a partition action. I know, for example, if the trial court enters an order saying that the parties are equal owners and tenants in common. I mean, that's what happened. So are you asking me, Your Honor, what the trial court should have done, or whether it had the power to make equitable considerations in allocating the tenancy in common?
Or whether, had it not applied 25-318, whether it had discretion to consider what allocation of ownership would have been given the remaining circumstances in the transaction.
Could you say it one more time, Your Honor, whether it had the...
Well, you are contending that it was error for the trial court to apply 25-318. Let's say we agree with you. Say 318 had no business in this case. Well, if the trial court is just applying 302 and had not fallen into that error, would it have had discretion to determine percentages of ownership based on the totality of the circumstances?
Yeah, I'm not sure the standard, the discretion for the trial court, Your Honor. I do think that the trial court would have had discretion to award that the property is owned by the parties tenants in common, not as a 50-50 split. And I do believe that the court could, just by analogy, based on my practice in family court, if it were making, on the analysis of 318, one of the factors the court could have considered in doing that would be the source of the funds to purchase the property.
So what, in your view, would then be the appropriate order if you were to succeed today? Would it be to remand for reconsideration in light of the totality of the circumstances?
No, Your Honor. I think that the parties had the opportunity to present evidence about equitable reimbursement. And that evidence was presented. Appellant's evidence was her time and effort and money spent invested in the house. Appellee presented evidence that he provided the source of the funds. So my request would be that the court just vacate the order.
Not for reconsideration in light of a legal ruling that the court applied the wrong statute, but just a out-and-out victory for your client then.
Well, Your Honor, I think that the appropriate procedure would be for the appellee to file a partition action. And that's, I mean...
that would be a do-over of the whole thing.
I don't agree, Your Honor. I mean, because the partition action wasn't considered here. It was requested and rejected. So the only considerations that were done here were considerations under 318. I don't believe that the law applicable to a partition proceeding for a partition of real property is the same as the standards under 318.
Right. Right, I think, yeah.
Well, but hold on, because you've really got me confused. There's one court, one action, they're saying we have a piece of property. There's an annulment. So the court now has to divide that piece of property. That is a partition action, right?
I don't think so, Your Honor. I think a partition action is
we're going to make form over we're going to take it and say, no, you have to go and you have to go over in civil court or file something under civil action rather than we're here, we're going to dispose of this property before this superior court judge.
I think that's a very good point, Your Honor. The problem is that the legislature did not include annulment proceedings in 318. If they had, we wouldn't have this problem, but they did not, and I think it was a deliberate decision to omit it from 318 because they don't want, I mean, the ease, the legislature has a vested interest in discouraging annulments, that they are not intended to receive the same protections, the same courtesies, the same community property overlay as annulment proceedings.
But in applying 25302,
Sure.
isn't the court supposed to apply the same standards that it would apply in a partition action? Isn't that your point?
I think so, Your Honor. I'm not sure. I'm not sure what standards it should apply. My position would probably
Then consider that issue.
I'm sorry, Your
If you're not sure, shouldn't the court then consider that if you're successful? I'm inclined to
Sure.
agree with you that 25318 doesn't apply, but 25302 says precious little.
Correct. So I would agree. I mean, if the court were to hold that 302 is the controlling statute and it doesn't provide for an equitable distribution, as happened in this case, then the answer would be either A, that the court in an annulment proceeding could have handled it as if it were an action in partition, or B, that the court should have done what it did here, which is, okay, you had community property right of survivorship, I'm annulling the marriage, void ab initio, therefore tenants in common, you handle the rest. So unless Your Honors have any further questions, I'm going to reserve the balance of my time.
All right, thank you. Counsel.
Good morning, Your Honors. May it please the Court, Michael Lincoln for appellee Michael Hammett. Your Honors, I believe appellant's two alternative arguments really center around the applicability of 25318, so that's where I think I'd like to start. In order to get to 25318, as Your Honors indicate, we essentially have to start with 25302. 25302 clearly provides that in annulment actions, the court shall divide property. Okay, we can stop there, but for context, I think it's important to look at the remaining language in 25302 because it goes on to say the court shall establish rights, obligations of parties with respect to children in accordance with 25320 in Article 4, Chapter 1. Article 4, Chapter 1 having to do with legal decision-making and parenting time. If we specifically look at 25320, which is the child support statute, 25320 makes no mention of being applicable in annulment actions. Instead, it indicates that it applies in dissolution actions, legal separation actions, maintenance actions, and child support actions. So there is no...
paternity actions, or you file a petition. To me, when you read those, it simply says that when you're annulling it, you're telling these parties in that context that have children, we're going to treat you like any other unmarried people, and you're going to have to file a petition to establish legal decision-making, parenting time, and child support. But you're already here, so we're going to do it for you.
And I agree, Your Honor, and essentially the point I'm making is despite the fact 25320 doesn't specifically reference annulment actions, it is well known that 25302 obviously does provide the court the ability to use 25320 as a vehicle to order child support in annulment actions. Likewise, I think the same argument can be made for 25318 because 25302 specifically and expressly states the court shall divide property. There's only one statute in the totality of Title 25 that deals with the division of property. That's 25318. So, if we are to assume that 25318, despite the fact that it's the only statute in Title 25 that deals with the division of property, doesn't apply, then we are forced to assume that the legislature intended to provide the court no guidance whatsoever as to how to divide property, which would essentially render the clause in 25302 meaningless. And the case law is clear that statutes are to be interpreted so that no clause is rendered superfluous. So why include the language, the court shall divide property, and then go on to provide no guidance whatsoever on how to divide that property? I think it goes against common sense and common logic.
Well, there's not much guidance in 25318 either.
Well, I think it's, and that's debatable, but certainly it's the primary statute relied on in any dissolution action, so certainly it's sufficient to preside over any dissolution action, and it's, in my view, sufficient for any annulment action.
A court can get a petition for dissolution, and then in the course of dealing with the dissolution petition, find out the parties were never actually married. Not an annulment; they were just never actually married. And we don't then subscribe to community property principles to this thing that never happened, do we?
Not necessarily, Your Honor. And that gets to my next point, and that is whether or not the relates back doctrine, which is cited in State v. Demitz, which appellant cited in his brief, as well as discussed in a Division II case, Hodges v. Hodges, should apply in this situation. And the relates back doctrine essentially indicates that obviously a decree for annulment invalidates the marriage from its inception. And so the question becomes, do we use that relation back doctrine to essentially unwind everything that occurred during the supposed marriage or not? In Hodges v. Hodges, the court, Division II, was dealing with a spousal maintenance provision. A former wife entered into a second marriage, which would typically terminate the spousal maintenance provision from her prior divorce. The second marriage was later annulled. So the question was, does the relation back doctrine apply to unwind the second marriage and essentially revive that original spousal maintenance provision from the original divorce? The Division II court held that due to policy considerations, the relation back doctrine should not apply in that situation. In State v. Demitz, this court was dealing with a child support obligation that had been terminated due to a minor child's emancipation by marriage, which was later annulled. So again, the question was, does the relation back doctrine take effect to unwind that marriage and revive the child support obligation by father to his minor child? This court found, due to the public policy considerations, that it should apply in that situation because there are strong Arizona public policy that parents obviously be financially responsible for their children. Bottom line, in both situations, it came down to public policy. The court had to look at public policy considerations to determine whether or not that doctrine would apply in that situation. My question for this court is what public policy would be furthered in this case to not hold wife responsible for half of this debt?
I think you're making an equity argument.
Essentially, I am, Your Honor. And a common theme throughout the case law as well as...
And then it goes to my question would be, is equity, and it's the same when I believe we asked counsel, does equity play any part in a partition action?
To the extent the family court can treat it as a partition action once the annulment is in place, I would argue yes, because family court is a court of equity.
Any case law that would support you that equity plays a part in a partition action?
Not with me today, Your Honor, but that would be my assumption.
I guess the public policy that I might want to look to is transactional predictability. If this were not a piece of real estate, a piece of personal property that one putative spouse buys for both to use, what would our answer be? Let's say that there was no loan, there was just cash, and the putative husband buys a car for both sides to drive with cash, and now we have an annulment. What happens then?
So both parties are on the title.
Well, in that situation, obviously, it's hard for me to answer that question, Your Honor. At the end of the day, I think it comes down to evaluation. And I know we're not talking about 25318B, but I think it's important to point out in 25318B that the legislature intentionally included in that language that in dividing property, debts related to the property may be considered.
Right, but my hypothetical involves no debt.
Understood that there's no debt in that hypothetical. At the end of the day, in valuing that property without there being any debt tied to it, presumably that property would be divided equally amongst the parties. In this situation, I don't think you can consider properly the value of the property.
Why would that be? Why would it be different if one party contributes substantial cash versus contributing substantial debt? Why would the result differ?
I think Toth might provide some guidance on that, Your Honor, and to the extent that in that case, obviously, husband contributed sole and separate funds towards the purchase of a home, and at the end of the day, it came down to a concept of fairness in that case. And
It came down to an equitable division of community property, considering sole and separate property and other things. But that's not what we have here. We do not have a community property issue. We have simply an annulment with a partition action, right?
If the court wants to apply the relation back doctrine, then yes. In our view, the relation back doctrine, again, comes down to a public policy consideration, whether or not that should be applied in this situation. I don't see the public policy that would be furthered by the court applying that in this case.
Did you in your research find any cases concerning a third party's effort to enforce a debt like this one? That was a sole and separate debt entered into, or a debt entered into and signed only by one of the parties to a marriage during the marriage?
Your Honor, I believe I did come across some case law to that effect. I do know that the case law is clear that to the extent third-party interests could be adversely affected, the relation back doctrine should take special consideration of those instances.
So, in those cases, the third party is able to enforce the debt against both parties, or only against the one that signs?
I didn't take it so far as to determine whether or not the third party would be able to enforce against both parties or not. Simply took it to the level of, to the extent third party interests would be adversely affected, that is to be given special consideration as well.
Okay. Your adversary talked about claims that his client had for reimbursement of expenses, and that she paid toward the upkeep of the condo during the time of the marriage. Did your client also have such a claim for reimbursement of expenses that he made and that was litigated?
Well, Your Honor, the totality of the loan that was taken out that was in question was essentially,
Right.
It covered the entire purchase price of the condo as well as home improvements that were done to the condo initially at the outset.
So
The receipts mentioned by counsel that were submitted by the wife during the trial were over a course of a 4-month period, and they allegedly totaled approximately $30,000. Of note, and presented as evidence at trial, was the fact that the wife's W-2 income for that year was approximately $16,000. So that's prior to taxes, food, utilities, etc. So the court did consider those receipts totaling upwards of $30,000, but quite frankly, I think it's disingenuous to suggest you paid for those solely by yourself with a $16,000 salary.
So to the extent that there are claims for reimbursement of expenses paid, it would be your client's position that separate and apart from the purchase price, your client also used the proceeds from his loan to pay for.
Yes, Your Honor, and that was uncontroverted at trial, that the loan was used for the purchase price as well as for flooring, paint, cabinets, and plumbing that were put into the condo initially from those loan proceeds. As far as counsel's argument that this essentially constituted a gift, Your Honors, I disagree. The loan was taken out during the marriage, albeit the marriage was later invalidated, but the deed was put in both parties' names, and essentially counsel is relying solely on the fact the deed was put in both parties' names to suggest that this was now a gift to.
And that's the interesting question for me, is that there's a presumption of gift during the course of a marriage when that kind of scenario happens. But now we don't have a marriage, so do we still have a presumption of gift?
Even if there is a presumption of gift, Your Honor, I think the court still has to consider the debts related to the property, regardless of whether there's a gift of that property or not. Otherwise, it can't be properly valued. And otherwise,
Well, there was no debt on this property.
There's debt related to the property.
How's that? Where's the debt related to this property?
The debt was secured by my client's sole and separate property, but used solely for the purpose of buying the condo.
So there was no debt on this property. It was free and clear.
It was related to the property.
But the property secures no debt, correct?
The property itself is secured by no debt.
And do we even need a presumption? If your client puts the title into the names of both parties, which was unnecessary, doesn't that provide evidence of a gift on its own? Your client, if your client's taking out a loan on sole and separate property and buying it, your client doesn't have to attach more than one name to the title.
He doesn't, Your Honor, but I think the case law on that issue is also clear in that the gift, so to speak, does not necessarily constitute a irrevocable gift of property rights. Rather, it's a gifted interest.
Well, no. I'm again going away from presumptions. I'm just looking at this transaction. In this transaction, your client buys something using his own money, securing it with his own sole and separate property. He could have just kept it for himself. Worried about community property implications if there was a divorce later, but instead took the affirmative step of placing somebody else on the title.
Well, and that hypothetical, again, I think is premised.
Not hypothetical. That's real. That's exactly what happened here.
Well, it's premised on the fact that the loan was taken out was my client's sole and separate funds, which at the time it was taken out, it was not.
Why is that?
Because it was taken out during the marriage. Now, the annulment invalidated the marriage. So if we want to rewind things and, again, apply the relation back doctrine to the annulment.
But your client used sole and separate value to secure that loan.
To secure it. It doesn't, just because the security is sole and separate property doesn't make the debt itself sole and separate.
Fair enough. But the fact then that there's this debt that arguably appeared to be community at the time, it was secured by sole and separate assets. So there was no natural need to place two names on the title. One party's property bears the burden, whereas both parties enjoyed the benefit. That's not necessary, and that would seem to be evidence of an intent to create a gift.
And it could be treated as such. Again, I don't think it gets to the heart of the issue in that even if it is essentially a gift, that the debt related to the property still needs to be addressed.
Well, if you give somebody something, aren't you done? I mean, I'm sure there lots of people would love to retract lots of gifts they make, but once the gift is complete, there's no more analysis.
And I would just go back to Your Honor that the fact that at the time that the loan was taken out, it was during the course of a valid marriage, taken out during the course of the marriage. It was intended as a gift to the community. Whether or not this court chooses to apply the relation back doctrine ultimately will come down to public policy analysis.
Does the reason for the annulment factor into any of this?
I don't believe so. In any research that I've done, I don't know that the actual reason for the parties annulling the marriage had any bearing in the division of the property.
Interestingly, 25302 does not contain the language from 25318 that says without regard to marital misconduct.
I would agree, Your Honor, does not contain that language. You know, further questions, Your Honor, I'll rest.
All right, thank you. Counsel, any final word?
I'd like to quickly address the public policy considerations brought up by my colleague. I would agree that public policy is very significant in this case. I would disagree that this would be an inequitable or this would be a time for the relation back doctrine. I think when Judge Johnson asked about the reason for the annulment, I think it is relevant, at least insofar as the decree of annulment made findings that both parties knew that the marriage was invalid when they entered into it. It would seem that it would not be inequitable now to hold appellee to the consequences of knowing that he was not entering into what was going to be a valid marriage. The other policy consideration that Judge Swan brought up, being transactional predictability, I think is extremely relevant. And it goes to the question of whether or not this was a community or would have been a community debt when it was taken. I think that we need to establish that 25214C, which provides exceptions for binding the community, would apply in this case if this were a dissolution proceeding. It requires the jointer of both spouses, written jointer, to be liable for a debt, even if it were a marriage. I think that this court has held in the past that provision is not only intended to protect or regulate relations between the spouses and third parties, but also relations between the spouses themselves. For example, in this case, the appellant probably would not have invested such a significant portion of her life savings into the property if she had known that she wouldn't be able to keep it, or that would have been applied towards this unrelated debt. Finally, Your Honor, I just want to clarify that I don't agree with my colleague that it was uncontroverted at trial regarding the application of the proceeds from that loan that were in excess of the purchase price. There was conflicting testimony on that.
Did the court rule on any of that?
Well, yes and no, Your Honor, in that the court ruled in its decree that all of the requests for reimbursement were denied, with the exception of the reimbursement for the purchase price. Which so I'm not sure then whether that ruling means that appellee's request was approved or not. If there are no further questions, I will yield the balance of my time.
All right.
Thank you.
Thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course.